The Honorables, the presiding Chief Judge and Judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Thank you, Mr. Soar. Good morning and welcome to the North Carolina Court of Appeals. We have already had one oral argument this morning, and we will proceed with the second case on our calendar. Kia Towns versus Portfolio Recovery Associates, LLC. Are the attorneys for the parties prepared to move forward?
Yes, Your Honor.
Yes, Your Honor.
Okay. Thank you. You'll hear, first of all, from the plaintiff appellant.
Thank you, Chief Judge McGee, and may it please this court. My name is Jason Pickler, and I'm a staff attorney at the North Carolina Justice Center, and I'm appearing on behalf of the plaintiff, Kia Towns. I'm primarily here to answer your questions, but if there's time, I plan to focus on three points that pertain to fundamental issues that undergird both plaintiff's appeal and PRA's cross appeal. Point number one, the statutory language is plain and unambiguous and should be enforced as written. Based on the ordinary and well-known meaning of itemized accounting and itemization, the statutes at issue require a debt buyer to itemize all fees and charges that make up the amount claimed to be owed, not simply post-charge-off fees and charges. Point two, PRA's contrary reading amounts to a complete reimagining of the statutory language. In particular, PRA's argument that the charge-off balance is a standalone item that need not be explained cannot be reconciled with the actual words used by the legislature and offends rules of statutory interpretation. It also contravenes the purpose and spirit of the statutes as enacted by the Consumer Economic Protection Act of 2009, which, as the title suggests, was intended to protect the economic interests of consumers, not debt buyers. Finally, PRA also failed to comply with the plain and unambiguous statutory language that requires a debt buyer to attach to its complaint particular documentation that establishes a complete chain of ownership of the particular debt. And because the court's task here this morning is to interpret the statutory language, I think what I'm going to do first is bring up the statutory language so we can look at it together. So looking at section 5870.115, I have subdivision 5 and subdivision 6. Subdivision 5 provides that a debt buyer commits an unfair practice when it brings a lawsuit or otherwise attempts to collect on the debt without reasonable verification of the amount of the debt allegedly owed. The statute specifies what is required for a reasonable verification. It indicates that it shall include, among other things, an itemized accounting of the amount claimed to be owed, including all fees and charges. And so the statutory text here is clear about what needs to be itemized. It's the amount claimed to be owed and the granularity that must be included in the itemization. It must include all fees and charges. Now, PRA argues that the word itemized accounting, the phrase, is not defined in the statute, and therefore it feels free to range widely around federal regulations and other states' laws. But the rules of statutory interpretation are clear that undefined terms in a statute are accorded their ordinary and common usage. And the parties agreed at summary judgment that a proper definition of to itemize in the context of an accounting is to set down in detail or by particulars. So the language itemized accounting is not an ambiguous phrase. It has a common definition, and that common definition, moreover, has been applied by this court, and which shows that it has been used to consistently to show that an itemized accounting must contain all of the fees and charges that make up the balance. And I'm referring to the Bramco and Unifund CCR Partners v. Dover cases, where in the Unifund case in particular, it was a case involving a debt buyer seeking to collect on a credit card debt. And the question was whether the creditor had provided a verified and itemized account under Section 8-45. And what the debt buyer was trying to do was use a single monthly account statement as a itemized statement. And this court said that that was hardly an itemized accounting because it only it started with a previous balance and only itemized a $70 purchase and a late fee. And that wasn't good enough. And because it didn't itemize the amount claimed to be owed. And that shows that the words itemized accounting not only have a common dictionary definition, but that definition has been implemented by this court in such a way that it is a well-defined term. And as we noted in our briefing, in the Fidelity Bank case, the word interest. Oh, I'm sorry, Chief Judge, did you have a question?
I was going to ask Mr. Pickler, what do you say was not included in this particular action?
So in this particular action, like in the Unifund CCR Partner v. Dover case, PRA attempted to rely solely on the charge-off statement in order to meet the reasonable verification requirement of the statute. And so, like in Unifund, a charge-off statement starts with a previous balance, and the 30B6 witness for PRA admitted that PRA had no idea what charges and fees composed that previous balance. And the only itemized amounts on the charge-off statement was a $35 late fee and a $32.03 interest charge. That was the only thing that's itemized on the charge-off statement. And so the plain language of subdivision 5 here requires more than just a single late fee and a single interest charge. It requires all fees and charges. It's the plain and meaning of the words itemized accounting of the amount claimed, including all fees and charges.
But sir, all fees and charges for what period of time?
Well, it would be all fees and charges that make up the amount claimed to be owed. So that would depend entirely on what the debt buyer is claiming is the amount claimed to be owed. Here, it is the charge-off balance. They are claiming they purchased a charge-off balance from the account seller, and they're seeking to collect on the charge-off balance. So they need to provide all fees and charges that make up the charge-off balance.
No matter what time frame was involved.
Right, no matter what time frame was involved. And I think that PRA attempts to make that seem onerous and too burdensome. But there are 2 points there, Your Honor. One is that the debt buyer is the master of its complaint. It can choose how much to claim to be owed. So if it only has one account statement or two account statements, then what it needs to do is claim the amount that is provided or itemized on those two account statements. But if it wants to buy a debt for pennies on the dollar and then seek to recover the entire amount, under North Carolina law, it needs to make sure that it can itemize that entire amount.
So is it your contention that they must itemize what all the charges were, each individual charge was within the credit card?
That is our contention, Judge Arrowood. And again, if
so if I went, let's say I went to Starbucks and charged $15, and then I went somewhere else and charged $25, and somewhere else and charged $30. That bill didn't get paid. There was interest. Eventually, it was written off. You're contending that it's got to itemize the Starbucks bill, all of those specific charges in each for each account that hasn't been paid that's been written off. Is that your contention?
That is our contention, Your Honor, because this is a debt. When a debt buyer seeks to collect on the debt is rather old at that point, and they're buying this debt again for pennies on the dollar and seeking to collect on the face value, and they need to be able to verify all of the charges and fees. They cannot just presume the accuracy of the charge-off balance that they're receiving from the account seller. And the debtor shouldn't be forced to presume the accuracy of that amount either. I'm sorry, Judge Zachary, are you?
No, excuse me. If you know, is there documentation of the account history included when this debt is purchased?
I'm sorry, Judge Zachary, could you repeat that?
If you know, is there documentation of the account history when the debt is purchased? Is that included with it?
You know, it appears that typically it is not included, but that doesn't mean that it can't be included. And, you know, the reason why the debt is being purchased for, 4 cents on the dollar, part of that is because the debt has been deemed uncollectible by the original creditor, but it's also because the debts are being purchased as is with very little documentation. Now, if it may be that they're not receiving the type of itemization that they need to recover the entire charge-off balance, but then they need to seek a lower amount that they can itemize, or go back to the original creditor and say, you know, in North Carolina, we need to itemize the amount claimed to be owed. So you're going to have to give us more than you're currently giving us.
Now, has any other state or any other jurisdiction found that the itemization needs to be to this granular level that your continuing statutes require?
I know that the state of Wisconsin also required a full itemization of the debt. That their statute was amended, I believe, in 2015 to no longer require a full itemization, that it only needed to require, I believe, the charge-off balance. But our contention, Your Honor, would be that the statute in North Carolina is clear that a debt buyer, when seeking the charge-off balance, that's the amount claimed to be owed. So they need to be able to itemize that charge-off balance. If they want the statute to read as they're claiming it reads, then they need to go to the legislature. The statute is plain and unambiguous and should be enforced as it's written, and it's PRA cannot be allowed to amend the statutory language. And the fact that North Carolina may have more robust consumer protection laws, that is the way that our country works. The laboratories of each state is able to enact the regulations that they deem best for their consumers. And North Carolina's legislature in 2009 decided, as a policy decision, that it was the right move to require a debt buyer, based on issues with the debt buying industry, to have to meet a significant, a heightened requirement where they have to itemize the entire amount claimed to be owed. If the legislature had only wanted to require the charge-off balance and any post-charge-off fees, they would have said so expressly. And in fact, if I could share my screen again, what we can look at the section 155, which pertains to the requirements that a debt buyer needs to satisfy in order to obtain a default judgment. And 155 requires that the debt buyer submit to the court properly authenticated business records that include all of the following. And in 155B5, you see the original charge-off balance. In 155B6, we see an itemization of post-charge-off additions. So it's clear that the legislature knew quite well how to require a debt buyer to provide or to have an original charge-off balance and to require an itemization of post-charge-off additions. The fact that I'm sorry.
Were there any additional post-charge-off additions in this particular case?
No, there were no post-charge-off additions here. PRA sought to collect on the charge-off balance. And so in 155B4 requires an itemization of charges and fees claimed to be owed. And 155B5 requires the original charge-off balance. So when they're only seeking the charge-off balance, the itemization of charges and fees claimed to be owed are those that are owed at charge-off. If they seek to collect on amounts beyond the charge-off balance, then they need to provide an itemization of those post-charge additions under Rule 155B6. But what's clear here under the rule of statutory interpretation that's articulated in the State v. Milet case that we cite in our brief, that when the legislature has deliberately chosen a word in one section of a statute and has not used that word in another section of the statute, that inclusion and exclusion is presumed to be intentional and deliberate. And so here the legislature deliberately require a specific item of the original charge-off balance and an itemization of post-charge-off additions. If that's all they wanted 115 subdivision 5 and subdivision 6 to require, they would have used that language. The fact that they used a different formulation, an itemized accounting of the amount claimed to be owed in subdivision 5 and an itemized accounting of all amounts claimed to be owed in subdivision 6 necessarily requires us to interpret those formulations differently. If all they wanted was the charge-off balance and post-charge-off additions, they would have used that language, but they didn't. It's clear that they intended, I'm sorry, Judge Arrowood.
Is it a reasonable interpretation of this statute? Isn't another reasonable interpretation of the statute that what the statute intended to require was that they intended to require an itemization, but that the itemization did not have to be to the granular level, but to this amount of charges for fees or services, this amount of interest, this amount of late fees, those various categories.
So not the Starbucks charge and the gas station charge, but there's a total amount of purchases.
This is the amount of late fees. This is the amount of charges. This is the amount of late fees.
Okay, I understand, Your Honor. Thank you. I think that isn't a reasonable reading of the statute for the reason that in 115 subdivision 5, it says a itemized accounting of the amount claimed to be owed, including all fees and charges. And so when we combine the common understanding of the word itemize, which is to set down in detail or by particulars, with the language all fees and charges, I think that the granularity there is that the legislature wanted the debt buyer to be able to verify the debt with all of the various charges and fees that make up the account balance, and importantly, to then in 115 subdivision 6 to send that itemized accounting to the debtor before filing a lawsuit. Why? So that the so that the debtor, prior to being sued, can be put on notice of all the fees and charges that are being claimed, so that instead of just a total amount, you owe this, the debtor is allowed to see these are the charges and fees they're claiming that I owe. I recognize these charges and fees. I go to that Starbucks. I go to that gas station. These are my charges and fees, and I can do something with that information. I can either avoid the lawsuit by entering into a payment plan, or these charges and fees, I don't believe they're accurate, so I'm going to dispute them. But it arms the debtor with information that they are that it enables them to take action. And by withholding that information, PRA deprived Ms. Towns of that opportunity. And furthermore, in Section 155, again, where this is a debt, when debt buyers file lawsuits, more than 9 out of 10 of them result in a default judgment. And so there's not going to be any adversarial testing of the evidence. And so what the legislature wanted the debt buyer to do was to, instead of just presuming the accuracy of the information they were receiving from the account seller, they had to verify those debts and then be able to submit and file an itemization with the court so that the clerk of court didn't have to presume the accuracy either. And this relates back to Section 8-45. The Bramco and Unifund decisions were relating to a debt collection statute that used the itemized and verified account to as an evidentiary standard, that if they satisfied the itemized and verified accounting, it would be a prima facie evidence of the correctness of the amount. So in other words, the amount would be presumed correct until proven otherwise. In a debt buyer lawsuit, there's not going to be an adversarial testing. And so the legislature rightly imposed that same level of robustness on what a debt buyer must show before obtaining a default judgment. They need to be able to show an itemized accounting. They shouldn't be allowed to presume the correctness because there won't be any adversarial testing at the end of the day. So if there are no further questions about that issue, I'm going to turn back to the language. So again, PRA's main argument is that 155B5 reads that the charge-off balance is an item that needs not be explained. But that language in 155B5 is untenable. It's a misreading of the language. 155B5 says the original charge-off balance needs to be provided, or if the balance has not been charged off, an explanation of how the balance was calculated. It doesn't say a charge-off balance need not be explained. And PRA is conflating the word itemization with explanation. And that is improper based on the State v. Milet rule of statutory interpretation that I discussed earlier. If the legislature had intended the words an explanation of how the balance was calculated to mean nothing more than an itemization, then it would have used the word itemization as it did in 155B4 and in 155B6. It chose not to use the word itemization, and we need to presume that was done intentionally. An explanation of how the balance was calculated is not an itemization. An explanation of how the balance was calculated is an explanation of the computation method used by the creditor. So for example, in a credit card situation, there are many different ways of calculating a balance. You could use the average daily balance prior to new purchases, or the average daily balance after new purchases, or other methods altogether. And so that is what is being required here, not an itemization. And we know that based on the plain actual words used. If explanation only meant itemization, the legislature would have used that term. And that is the crux of PRA's case. Without that argument, their reading of the statute essentially falls apart. They are relying, and they use the term throughout their brief, the charge-off balance need not be explained. It need not be explained based on their reading of 155B5, but that reading, again, is untenable based on the actual words used. I'm seeing I'm about to hit the 5-minute mark, so I think I will reserve the rest of my time unless you have a further question.
I
Okay,
just want to ask you just briefly, if I might, about your last argument there about including and attaching to the complaint the complete line of ownership of the debt.
Yes, that's the section 5870-150 subdivision 2 claim. And
Right.
that requires both that the debt buyer attach each assignment of the debt. So here, the debt originated with HSBC Bank Nevada, was transferred to its parent company, and then sold apparently to Capital One Finance Corporation, and then assigned to Capital One Bank NA and Capital One NA. But there are missing assignments in that chain. We don't see the assignment from HSBC Nevada to the parent company, and we don't see the assignment from Capital One Finance to these banks. Those are missing from the chain of assignment. And also the statute requires that each assignment contain the name of the debtor and the account number. And if you, we don't have time to go into it, but the documents that were provided do not provide Ms. Towns' name or an account number. And so they violate the statute in 2 different ways.
Thank you.
You're welcome.
Hammond? You need to unmute, sir. We've all done that this morning.
Thank you, Your Honor. May it please the court, my name is Joe Hammond. I represent Portfolio Recovery Associates. I'm here with my colleagues John Berkelhammer and Michelle Ligori. PRA purchased one item, the charge-off balance for Miss Towns' credit card. PRA obtained documentation from the credit issuer documenting that charge-off balance. And that documentation was the charge-off statement. PRA did not add any fees or charges to that item that it purchased, the charge-off balance. Because PRA only sought that one item, it fully complied with each of the itemization sections of these laws when it attached the charge-off statement to its notice, obtained the charge-off statement before attempting to collect the debt, and attached an authenticated copy of the charge-off statement to its motion for a default judgment. There was not anything else to list or to provide notice of to the court or to Ms. Towns.
Mr. Hammond, if you don't mind, could we start with the ownership, documentation of ownership of the account?
Yes,
Do you mind starting with that issue?
yes, Your Honor. So that's the attachment requirement, which is section 150. And PRA satisfied that requirement by attaching account statements showing that the Ms. Towns' account had been transferred from the original issuer, HSBC, to Capital One, and then as well as an SEC filing that shows that HSBC sold its entire credit card business to Capital One. And both of those documents were attached to the complaint. The account statements contain Ms. Towns' name and account number as required by section 150. And so those documents attached to the complaint evidence the transfer from HSBC to Capital One. Then the account was transferred next from Capital One to PRA. and PRA attached a writing evidencing that transfer and establishing that it is the owner of Ms. Towns' debt by attaching the bill of sale showing Capital One selling a set of accounts to PRA as shown in a electronic data file. And then PRA attached an excerpt from that data file showing that Ms. Towns' account is one of the accounts that was transferred. And that excerpt also contains Ms. Towns' account number and name in full compliance with Section 150.
Well, how do you respond to Ms. Towns' argument that you did not fully comply because you don't show any evidence of transfer from HSBC Nevada to HSBC Financial Corp, and then you don't show a transfer from Capital One Finance Corp to Capital One Bank, NA, and Capital One Bank?
Your Honor, the statute speaks of transfers of ownership, not transfers of title. And ownership of property held by a wholly owned subsidiary under North Carolina law is imputed to the parent. Here, the parents were HSBC and Capital One, so there was not any requirement to document intra-corporate transfers of title. And the reason makes perfect sense. There's not a risk that one HBC entity and another HBC entity are going to both be suing a North Carolinian saying, I own your debt, whereas the other one says, no, I own your debt.
Well, but here, weren't there two bills of sale? You know, one from Capital One Bank NA and one from Capital One Bank. So actually, doesn't that kind of indicate that perhaps there could be that problem?
Respectfully, I don't think so, Your Honor. The second bill of sale, which is from Capital Bank USA, that was included by accident, is my understanding. And Capital One NA was the owner of the account.
But didn't it have this town's name and account number on it?
No,
First bill of sale?
the excerpt of the account files that were transferred had her name and account number. That was printed from records provided to PRA by Capital Bank NA. And so my understanding of what happened is there was a purchase of accounts from two subsidiaries of Capital One. PRA included both sort of out of an abundance of caution, but in truth, the Miss Towns' account, the title had been held by Capital Bank NA, not by the other entity listed on the second bill of sale.
So wholly owned subsidiaries do own different accounts.
Title, I agree that title can be held in different subsidiaries, but ownership is imputed to the parent company, and Section 150 speaks only of ownership. It does not mention the word title. It says, if the debt has been assigned more than once, then each assignment or other writing evidencing transfer of ownership must be attached. And so by selecting the word ownership, the legislature made it clear we're not concerned about one HBC entity and another HBC entity both suing a North Carolinian on a debt. We're concerned about, let's provide notice to this person to understand what is the evidence that PRA is going to come forward with later on to say, we bought your debt and we own it.
Doesn't title indicate ownership?
Title and ownership are different in the corporate context, is my understanding, and that's what we've discussed a bit in the brief, Your Honor.
Thanks.
If I could turn back to itemization, unless there's further questions on attachment, I might drop back into it for a minute. On itemization, we see in Section 155 that the General Assembly itself included in the statute that a charge-off balance is one of the items to include in the evidence that is, and this is the evidence that the General Assembly tells us is sufficient to establish the amount and nature of the debt. And so Section 155, which is the most detailed recitation of the itemization evidence that the General Assembly thinks is important, clearly sets out that a charge-off balance is one such item. And as Mr. Pickler discussed, it further indicates that if the balance has been charged off, the calculation of that balance need not be explained. And that tells us that the General Assembly is interested only in the calculation of non-charged off balances. And that's
It only deals with default judgments and summary judgments. It doesn't deal with other lawsuits, correct?
That's correct. And PRA or other debt buyers could obtain a judgment at trial without ever having to worry about Section 155.
But you didn't in this case, is that correct? With respect to Ms. Towns?
With respect to Ms. Towns, PRA moved for default judgment.
Right. And doesn't the statute say all of the following items? It's not a listing of things that you can. It says must include at least all of the following items. And one of the following items is an itemization of the charges and fees claimed to be owed. And the next thing is the original charge-off balance or balance not charged off, an explanation of how it was calculated. So clearly, isn't the statute asking for, if you want a default judgment, that you've got to have both of those things?
I don't agree, Your Honor, and here's why. If we look at subsection B4, an itemization of charges and fees claimed to be owed, that's what Ms. Towns is hanging her hat on. And charges and fees is undefined, but we can understand what the legislature meant by that term, that phrase, by looking elsewhere in Section 115. And also looking in Section 110, which is the immediate preceding section of the of Article 70. Section 115.2 shows that by fees and charges, the legislature is referring to amounts incidental to the principal debt that have been imposed by a collection agency or a debt buyer, which is one type of collection agency. And that makes sense because the legislature is focused on conduct by debt buyers in these statutes and collection agencies more broadly in Article 70. It's not focused on conduct by credit issuers. As we can see from Section 155B5, it is not interested in how the credit card issuer calculated the charge-off balance. That is not conduct by a debt buyer or a collection agency. It is very interested in the fees or charges that are claimed to be owed by the debt buyer. And those are fees and charges that are imposed incidental to the principal debt, which is here the charge-off balance. They're add-ons by the debt buyer. Section 110 tells us that fees and charges, by that phrase, the legislature means amounts that a collection agency, including a debt buyer, threatens to impose to add to the existing obligation. Again, here the existing obligation is the charge-off balance. That is one item sufficient in and of itself. And the legislature is not interested in how was that calculated. The General Assembly trusts credit issuers. The General Assembly, by these statutes, is saying we're going to regulate debt buyers.
I'm sorry,
Now,
you referred to Section 110. What do you mean exactly?
well, Section 110 says,
Please give me the full site, sir.
oh, I'm sorry, Section 58-70-110, paren 6.
Thank you.
Is it possible for PRA to verify the amounts owed?
Well, yes, it is. This amount owed was fully verified by Ms. Towns herself. And
No, but in general, is it possible for PRA to verify the amounts owed by debtors?
is it possible for PRA to go behind the calculation of the charge-off balance? Is that what Your Honor means?
Yes.
On this record, I would say there's no evidence one way or the other. So talking about this case, there's no question that this balance is correct. Ms. Towns herself confirmed it. She agreed with it when she received the charge-off statement during the life of the account. She agreed with it when she was shown the charge-off statement during her deposition. She said she does not dispute it in the least.
But I mean, that was in her suit. It wasn't when she was defaulted. When she was defaulted, we didn't have her admission to that. But I guess what my question is when you buy this debt, do you have that kind of documentation available?
Well, let me try to answer it this way. It is impossible to break a charge-off balance into the charges and fees claimed to be owed. And that is because the way a credit card works, you go to Starbucks and you buy some coffee and there's a $5 charge. If you make, and then you buy a lot of other stuff, maybe you have a late fee, you have some interest. If you don't pay the full amount, the full balance for that period, and you only make a partial payment, which is sort of the normal course, then that payment is applied to the balance. It is not applied to an individual purchase, fee, or interest amount from past periods. And so we can't know whether your coffee at Starbucks from 3 years ago has been paid off or not paid off, or some proportion of it has been paid off. It is indeterminate because credit cards don't work that way. What we know is that it was rolled up into a balance. That next month, it was disclosed to the consumer as, here's your previous balance, which you didn't pay off. Here are your new fees, purchases, and interest. Here's your minimum payment. When they make a partial payment, it is just impossible to say whether it went to the pizza they purchased or the Starbucks they purchased or to a late fee or an interest amount.
So unless they bring it down to a zero balance, you'd have to go all the way back to the entire life of the account.
Well, you would have, I'm sorry, Your Honor. Yes, you would have to go all the way back to the entire life of the account. But crucially, that would not be an itemization of the amount claimed to be owed or an itemized accounting of the amount claimed to be owed. That would be something like an account history, a transaction history. These statutes don't require an account history or a transaction history. They don't use the words. They talk about an itemized accounting of the amount claimed to be owed, itemization of the charges and fees claimed to be owed. And that claim to be owed shows we want whatever the itemization need is, it's going to need to add up to what you're claiming. And you can't undo a charge-off balance and say, all right, because the Starbucks and the pizza are not going to add up to that balance once you make a payment. And so that's another problem with this, with Ms. Towns' reading, is sending a list of all fees and charges over the life of the account or since a zero balance. That won't verify anything. It won't add up to the balance because she's made partial payments. It won't include purchases. The legislature didn't say purchases. It won't include even interest, depending on whether you assume the legislature meant interest by charge or not. And so it won't verify anything. In fact, it will confuse the debtor. And here Ms. Towns recognized immediately the balance. But providing a list, 6.5 years in this case, of trips to Starbucks and other things she purchased that don't add up to the balance because payments have been applied to those balance will not verify anything to either Ms. Towns or to the court.
Well, I want to go back to your question about you can't tell where payments have been charged to or where payments have been accredited to. Doesn't credit card agreements usually almost always say that if you pay X, it goes to interest first or fees first and then interest and then against the balance? Doesn't the agreement itself that one makes with the credit card company have those calculations as to how things are going to be, payments are going to be applied?
No, Your Honor. If the federal regulation is 12 CFR 1026.53, which says credit issuers must apply payments to the balance, and I'm paraphrasing here, that bears the highest interest rate first. And so they are applied to balances, and that's just how it works. That's why it's a rolling balance. That balance sweeps up past fees, purchases, and interest, and those fees, purchases, and interest are not claimed as fees, purchases, and interest anymore. They are claimed as a balance. And at the end of the life of the account, when it is charged off, those fees, purchases, and interest from 6 years ago, they are not claimed as fees, purchases, or interest. They are claimed as a charge-off balance. And the important distinction here is, and this is something that I think Ms. Towns hasn't accounted for. Why would the legislature require explanation of the calculation of a non-charged off balance, but not require explanation of the calculation of a charged off balance in section 155B5? And the reason is this: the debt buyer has nothing to do with the calculation of a charged off balance by definition, because a charged off balance is by definition, the final balance owed on an account that is being inactivated and taken off the books, the accounting books of that credit card company. In contrast,
but
yes,
under your argument, you seem to be just writing 4 out, 7155-4 out of the statute, because you're saying that it's the same thing. But clearly, it can't be the same thing. Well, why would they put it in there? That's what I'm struggling with your argument with respect to 155. Why is it there if it only means they could have said the charge-off balance? Why is it there? That's why where I'm struggling with your argument.
thank you, Your Honor. Let me try to answer that. And see, so we're looking at 155. We say it's the opposite. If 155B4 requires that the debt buyer break down the entire balance that it seeks into all of the fees, purchases, and interest that have been rolled up into it over the life of the account, in that case, 155B6 wouldn't do any work, because the amount claimed to be owed, the claim to be owed would include any post-charge-off charges and fees imposed by the debt buyer.
Does not that charge-off additions talk about something that perhaps like PRA would be adding?
So as I read this, I would say, so let me step back. Post-charge-off additions, number one, that doesn't say post-charge-off charges and fees. It says additions. That's intended to be broader. That's saying we want anything that the debt buyer imposes, claims, anything new that it's adding on to the existing obligation or the principal debt. We want that itemized. We want the consumer notified of that, and we want the court notified of that. Why? Because we see elsewhere in section 587110 and section 587115, there are penalties for imposing bogus fees and charges by a collection agency. And so instead, 155B4 requires that it's the fees and charges that are claimed to be owed. Those, by definition, claimed to be owed as fees and charges would mean post-charge-off charges and fees. Because the debt buyer is not claiming past purchases, fees, and interest that have been rolled up into the balance as charges and fees. It's claiming those as a charged off balance, and we know the legislature isn't interested in how that balance was calculated by the credit issuer. And so if you read section 155B4 the way they do, there would be no post-charge-off addition to list. And then another point is, we can see in 155B6, well, if there's an addition that happens before charge-off, the legislature's not interested in an itemization of that either. And that also tells us the legislature's not interested in going behind that charge-off balance. Now, I think Ms. Towns, her point, well, section 155B4 should say post-charge-off charges and fees if it means what PRA says. I think that has some superficial appeal, but it's not correct. And let me explain why. Debt buyers purchase charged off debt, but they also purchase non-charged off debt. An example would be delinquent debt, and we know that from section 155B5. The legislature is aware of that. If the balance has not been charged off, we need to have an explanation of how you calculated that balance, debt buyer. If the legislature had written section 155B4 the way Ms. Towns claims it should have been written under PRA's reading, it would leave a gap where debt has not been charged off, the debt buyer purchases it. There would be no requirement for the debt buyer to itemize charges and fees that it adds to that balance and claims to be owed. And so I think there's superficial appeal of that argument, but when you understand where the General Assembly was looking at charged off debt and non-charged off debt and ensuring that courts and consumers have notice of all the charges and fees that the debt buyer is going to claim, it had to write 155B4 the way it did and say, we want the charges and fees claimed to be owed. And that refers to by the debt buyer.
And I'm sorry, sir, you said that subsection 6 says an itemization of post-charge-off additions. Whose post-charge-off additions?
I'm sorry, Your Honor?
Whose charge-off additions?
I believe that would be any post-charge-off addition.
That are made by whom?
That one could be made by anyone. It says where applicable. And so it could be attorney's fees or other expenses that someone is saying, well, you owed this debt and now we had to do this to try to collect it from you. We're adding that to your bill. But those post-charge-off additions would not have already been reflected in the charge-off balance. And therefore, the debt buyer is the one doing the adding of those. Even if say there was a debt that was charged off and then the bank made an addition to it, the debt buyer would be the one saying, well, we're adding that to the charge-off balance. And here, PRA only sought the charge-off balance. And so there was nothing else to list. Unless there are other questions, I'll save the rest of my time for rebuttal. Thank you, Your Honor.
Thank you. Making a note of the time.
Thank you, Your Honor. So I'd like to briefly start with the question that Judge Zachary began with on the attachment issue. And I think she zeroed in on the problem with PRA's evidence that it provided, in that they submitted 2 bills of sale, and now we hear for the first time that it may have been an error. But the point is that is the purpose of the statute, so that it presents a clear chain of assignment. We don't know that which of these banks owes the debt, and it's possible that after it's been transferred to another entity, they'll find out that, oh, we made a mistake. It was actually this other entity that owned the debt. And so there could be a problem. And then that is what the legislature sought to obviate. My friend on the other side also claims to be relying on account statements as proof that the attachments contained the account number and the name of the debtor, but the account statements are not an assignment or a document otherwise like an assignment. The statutory language requires an assignment or other document such as an assignment. And these account statements do not show a transfer of ownership. And they didn't argue below at summary judgment that they did, and they didn't make that claim when they filed their motion for default judgment. This is a new argument and it should be rejected. So moving on to the fundamental issue here on the itemization. Again, the Unifund case shows what an itemized accounting requires. It shows that it is not enough for the debt buyer or any debt collector seeking to rely on that statute to simply provide a single account statement. That in order to have the amount presumed accurate, you need to itemize the full amount of the debt. And if it's possible to itemize the accounting for purposes of 8-45, then why in the world is it not possible to itemize the debt for purpose of these statutes? My friend's argument that it's impossible to itemize a charge-off balance once there have been payments or whatever, then how does Section 8-45 work? How does a debt collector ever obtain a charge-off balance? There has been no proof provided by PRA that it is impossible, not a single authority cited by them for that proposition. That is a completely new argument that they alone have proffered. I see my time is running out, so I just want to emphasize the importance of these statutes, that they were enacted to respond to a debt buyer industry that was filing thousands of cases and is continuing to file thousands of cases in district courts around the state. The vast majority of those cases wind up with a default judgment against the debtor with no adversarial testing. That is why the legislature didn't want the court or the debt buyer or the debtor to have to presume the accuracy of the statement of the account balance. They wanted a granular itemization of that balance. Thank you very much.
Thank you, sir. Mr. Hammond? Sir, you
Am I okay to go?
fine, sir.
Okay, thank you, Your Honor. On Section 845, that statute is designed for the dry goods store where you keep a running account. There's no rolling balance there. There's not things rolling up and becoming principal and then bearing interest. It's just, well, you bought so much flour on one day and so many nails on another day. And so that statute is far removed from credit cards. And we also see the legislature did not use any of the terminology from Section 840-45 in any of these statutes. Section 8-45 speaks about an itemized statement of account. And that's the first time that we've heard those words today. It does not talk about an itemized accounting or an itemization of charges and fees claimed to be owed. And then the third point on Section 8-45, we've made some other points in our briefs, but one point is Section 8-45 is designed to facilitate the collection of debt that's not disputed. And it's going to a particular element of an account stated claim. And the element that it's going to is the calculation of the balance, which is the first statement in an account stated claim. That is what you would be using a verified itemized statement of account to accomplish. We know from the plain language of Section 155B5 that the General Assembly was not interested in understanding, verifying the calculation of the charge-off balance, because that was performed necessarily by definition by a credit issuer. And these statutes are intended to get at behavior and conduct by debt buyers and charges and fees claimed by debt buyers.
Mr. Hammond, I have a question.
Yes, Your Honor.
If this statute were held to require an itemization, what percentage or portion of the debt from North Carolina debtors owned by PRA would be rendered uncollectible?
Your Honor, I don't believe there's any record evidence about that. I would refer back to my answer that when a payment has been made, since that payment is applied to the balance and not to the Starbucks coffee or to the pizza, you can't say what amount is claimed to be owed for the Starbucks. You can't say whether it's $7 or $5 or $0, because it depends on how you applied that payment in the world of purchases and fees and interest that have been rolled up into the balance. And there's no rule there. It's just not done because the payment stays at the balance level. That's how the industry operates. Yes, Your Honor.
Well, but didn't you say you have account histories for some of the debt that you own? No,
I'm not aware of any record evidence. I mean, not in this case. There's no list of 6.5 years of purchases, fees, and interest that have been rolled up. That's true. Another point that I would make along those same lines is we can look at the federal regulations as well, which also reflect how the credit card industry operates. The federal regulations, as we pointed out in our brief, require disclosure of the previous balance and then interest and fees. And they say interest and fees must be itemized. They don't say new interest fees and fees must be itemized. They don't say interest and fees from this period must be itemized. The federal regulation, which is 12 CFR 1207, says interest and fees must be itemized. But as we know from the credit card statements we receive, that doesn't mean that an interest amount or a fee that was imposed 4 years ago is set out on that statement. That means the current interest and fees, which is all the interest and fees that in truth there are. The rest of them are part of and subsumed within and inseparable from the balance. And so we can see here that the North Carolina legislature adopted the same mechanism, but is applying it to the debt buyer. We understand debt buyers purchased a balance. We want them to itemize and disclose all of the charges and fees they claim to be owed. And that is what these statutes do. And since PRA did not claim any charges or fees, it's completely satisfied the statute through the charge-off statement. Thank you, Your Honors.
May I ask a question? When you talk about the fact that there were no charges and fees, should there have been a listing that said zero beside those topics to be able to give the plaintiff a little bit better information about what you're actually charging?
Well, I don't believe so, Your Honor. The notice of intent to sue, which was provided to Ms. Towns, states itemized accounting of amount claimed to be owed. It lists the charge-off balance and a space there. And so I think that's fully substantiates everything there is to substantiate. And Ms. Towns wasn't confused. She recognized completely that balance as one that she owed.
Thank you, sir.
Thank you, Your Honor.
Appreciate both of your arguments today. Thank you.
Thank you so much.
Thank you.
Mr. Soar?
This session of the North Carolina Court of Appeals is now adjourned.
Thank you.
Thank you.
Thank